I'm Steve Mail. This talk is about how I control commercial litigation with a sophisticated daubert motion practice, and about how I use these same daubert tools to help the law firms that are my clients exert the same control. It is an abridgment of a CLE speech that I recently gave to a meeting at the Defense Research Institute, and it is for attorneys and only for attorneys. If you're an attorney and you like this vignette, you may be able to get an hour of CLE credit for listening to the fuller version. But more interestingly, if you're an attorney, in such an hour I can show you how I can help you strengthen and probably expand your practice. I do this work at the highest levels, and my clients are drawn from the largest corporations, law firms, and insurance companies in the country. A non-trivial percentage of my clients are listed in Best Lawyers in America. It is my hope that you are a very good lawyer thinking, what can Steve Mail do for my firm that I can't do for myself? Because the better you are, the more you'll benefit from the work that I do. If you're not an attorney, you're welcome to listen, but please understand that I only accept other attorneys as clients. The practice that I describe here is both quantitatively and qualitatively different from the daubert motion practice that almost all other lawyers employ. A core notion of this talk is that daubert is a science-based opinion in which the court essentially requires that scientific expert testimony must comport with the scientific method and should bear the imprimatur of the scientific community that it so comports. My daubert motion practice differs from that of most other lawyers because I lawyer daubert issues from the perspective of the science that daubert requires before I lawyer the issue from the perspective of the law that the daubert court put into place to govern the admissibility of scientific expert testimony. In short, no matter how well you're trained in the law, and no matter how plenary your command of law has become, if you're not trained in science and you're trying to exclude scientific expert testimony, then you are not loading all the guns. The daubert criteria are widely misunderstood, even by otherwise sophisticated lawyers in courts, and this misunderstanding provides an opportunity for very high-value lawyering. 3 recent cases illustrate this misunderstanding and demonstrate the opportunity for high-value lawyering that it provides. But that demonstration will have to wait for a while because this is just a beta version of this posting to explore how well the technology works. The more complete version should appear here shortly. But if you can't wait, just click on the link to my left, go to www.daubertcounsel.com and look at Adventures of an Econometrician Lawyer under the link on litigating statistical expert testimony. Thank you.